Good morning. You are Jimmy Taylor. And Mr. Taylor, you were previously in court, entered pleas of true and a motion to revoke your unadjudicated probation. Counts 1, 2, 3, 4, 5, and 6. You pled true to all of those counts. You're on probation. Second-degree felony offense of theft of property with previous convictions with findings prior offenses were true. You were placed on that probation January 24th of 2024. I have received the pre-sentence report as well as there was one incident report from the jail page that should have been sent to you all, and also Mr. Coleman has also provided a copy of the court sentencing hearing, a transcript from that original sentencing back on January 23rd, 2024. Has everyone had an opportunity to review all of those?
Yeah. Yeah.
Are there any additions or corrections to that updated report? Yes, of course. So there's no agreement in this, correct? This is just open to the court.
When a defendant pleads true to probation violations, they're essentially handing the judge the keys. There's no trial on the violations anymore. No arguing whether they happened. The only question left is punishment. And that's where lives change in minutes.
And, all right. Mr. Rojas, you may proceed.
Thank you, Your Honor. We're going to be out for probation. Although I was going to be on Tuesday. It looks like that can't potentially get me. Just to give them criminal history, it looks like the criminal history is all somewhat rather judging on. You look at the allegations because the allegations have to do with judge. And the reason for not applying to JTF program. He's got a comfortable wealthy background. He doesn't have a whole lot.
This is the moment the courtroom tone hardens. The judge reminds him, "You played open. That's judicial code for, I already gave you mercy once." When a judge quotes their own past warning, it's usually not to soften the outcome. It's to justify what's coming next.
I'm sure that's one of the court point out that the comments made by the court about not wanting to get out to more help the judge or review it.
I really don't, because here's the thing, Mr. Johnson. I'm looking back at your original pre-sentence report that when I put you on probation. I make notations on those reports and make highlights and those types of things. And I'm noting that in that report, you already, before this case, had gone to ISF and safety. And then on this probation, I sent you to ISF at the beginning of the probation. Is that correct or no? So you were on parole. I gave you a probation against Mr. Coleman's wishes and really against what looked like I should have. You went to ISF regardless of who. So you've been to ISF twice. Is that correct? You're looking at her. You've gone. Have you been to ISF once or twice? How many times?
Twice. 1 year.
Okay, so you've been. But you keep getting. To do what? Because you've been to safety, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay. You got right on probation. You didn't. You tested positive for cocaine after all of this time and all the different things that have been given to you and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done anything. I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity. And I said on that day, because Mr. Coleman...
This is the moment the courtroom tone hardens. The judge reminds him, you played open. That's judicial code for, I already gave you mercy once. When a judge quotes their own past warning, it's usually not to soften the outcome. It's to justify what's coming next.
Handed it out for me. Well, so how do I do anything other than what I said? Hey, we're not talking about anybody but you today. I'm sorry your mom's that old and that you haven't been around to be with her, but that's whose fault? It's not going to be my fault if you're not there. How about some personal responsibility instead of my mama's old and don't send me to prison? Go ahead.
Not coming back 41 diarrhea, so I don't know if this is really do that. You haven't really got to go. All most recent confirmation with the CBI. We're going to check these we're going to take these there. We have for instance the appropriate for a whole new track.
Hold on. So if I'm reading this, I want to know when he went to IS this last time. Parole sent him when. Because the way I'm reading is you were released from ISF and started JCDI August 6th of 2024. So I put you on probation in January, and between January and August, you went to ISF last year. Is that correct or no? Okay. So when was that? Went straight there. So I placed you on probation. You never got out. You went and got help at ISF. All right. Anything else? No. No. I still haven't done anything yet. So your response and how you act right now is going to go into what I do.
For the fact, the underlying offer, the $50 getting off, $100 worth of mission, right? So I would ask for it to get it lower in the range, and just do the 5. Yes, it can drop it around. I don't think that's the theory for Steve. That's what we're asking for. Vision not to be an option.
Thank you. Mr. Coleman.
Three things I couldn't point out in our based on doing JPD alcohol, he was Michelle, set him up for failure, so I appreciate on that. All responsible. Sources and time, really resources not put out in redirect to fill up with what we will lessons you guys in the original and I provide you with transcript just to remind you essentially told
The prosecutor just dropped the most dangerous phrase in probation cases, zero tolerance. That means relapse isn't viewed as recovery. It's viewed as defiance. At this point, the courtroom isn't debating whether help exists. It's deciding whether the system has already tried enough.
And I do appreciate that because I do see a lot and I don't remember it all. But Mr. Taylor, do you have anything you want to say?
You know, do a lot of things in life, I was down those great skills, objects. That's very funny as a chance to talk about
Mr. Hughes, you have. But, well, you, it doesn't make any sense because you're saying, you've done a lot of time, and at some point, you either say, I don't like prison and I want to do better, but you didn't take advantage of the opportunities you were given. You're saying you want help, and we gave you help. Our parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things, and you got out, and you didn't take advantage of the opportunity that I told you. You better take advantage of it because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF or at safety. It's all the same thing that you're saying. And no one is setting anybody up for failure. Hang on. So what you're telling me is that when did you have back surgery? Okay. Listen. If you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that. I'm going to find that you previously entered your pleas are true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Y'all need to sign that, and he'll give you a copy of it. Thank you. Thank you, Dan, for being here. Ms. Holmes on Demario Flucas. Hey, come back, Taylor. Come here. Let me tell you something. I still have jurisdiction over your case. So any disrespect that you show me right now, I can add years to that number. Is that what you would like to do? I do think it's fair. It doesn't matter that it's a misdemeanor. You keep doing it over and over. Go back with the bailiff. And you probably should keep your mouth shut.
And there it is. 12 years. Not the maximum, but far from mercy. Then comes the final reminder of courtroom power. Disrespect doesn't end at sentencing. Judges retain jurisdiction in that moment, and attitude can still cost freedom.